Good evening, everybody. Thank you very much for coming this evening. My name is Penny Green. I'm a professor in the Dickson Poon School of Law across the courtyard. I'm also the director of the International State Crime Initiative. And tonight, it gives me enormous pleasure to introduce our speaker, Professor Richard Falk. Richard is also one of ISCI's honorary fellows, and we're delighted that he is visiting the law school this semester as a distinguished visiting professor. Many of you will be very familiar with Richard's illustrious career. He is Albert G. Milbank Emeritus Professor of International Law and Practice at Princeton. He was at Princeton, in fact, I think for the biblical 40 years. And he's now a research professor at the Orphalia Center for Global and International Studies at the University of California in Santa Barbara. He's also the UN Special Rapporteur on the occupied Palestinian territories and has been in this role since 2008. He has, in fact, just submitted his third and final report to the UN Human Rights Council in New York. He'll end his tenure in just a few months. And I think we can only hope that his replacement has a modicum of the integrity, passion, and moral strength that Richard has demonstrated in his role as representative of the occupied territories at the UN. I think one more thing I'd like to add about Richard, I don't want to spend too much time because you're here to hear him rather than me, but I'd urge you to take a look at Richard's blog, which he started in celebration of his 80th birthday, which I think is an absolutely marvelous way to celebrate. It's a wonderful blog. It's a powerful, intellectual, passionate, political blog, and I highly recommend it. Richard is going to speak this evening on severe state crime and double standards. He'll speak for around 45 minutes, and then we'll open the floor for questions and answers. Following that, at around 8 o'clock, 8:15, we'll repair to Chapters, which is on the first floor, for a reception. There'll be people to guide us downstairs. So I'm not going to say very much more at this point, but I do want to give special thanks to Alicia Delacour-Venning and Fatima Kanji and Gemma Noyce for organising this event this evening. So thank you all very much, and welcome to Richard Falk.
In my pocket. Let me begin by thanking you all for braving the London weather and being here tonight. Of course, the London weather always seems somewhat similar, so you probably wouldn't be doing very many things if you were intimidated by the weather. And I want to thank particularly Penny Green for her gracious introduction and for the hospitality that she has so warmly and excessively bestowed on Hilal Elver, my wife, and myself, and we're very happy to be here. Having these very dramatic posters behind me makes me feel as though I'm about to be indicted. But I'm very glad also to be associated with the with ISCI. I think there's nothing in our world more important at this stage than to focus on how to address state crime. And in my view, the future of democracy really depends on the capacity of people to control the state by way of law and justice. And if that doesn't happen, and it doesn't seem to be happening at the moment in many crucial settings, I can't imagine a positive human future. So it's an indispensable and neglected dimension of the legal order. I want to focus tonight in these remarks on the tension that I believe exists between law and justice in the international settings. And let me clarify what I mean by that. In relation to state crime, and particularly accountability for crimes of an international character, there has been an impressive evolution of legal doctrine that purports to hold accountable those who engage in criminal activity under the aegis of states, acting on behalf of states. And that's something that goes back to the reaction, I think, that was so important after World War II, and the sense that what happened in Nazi Germany and to a lesser extent in Imperial Japan could not be allowed to be repeated, that there had to be a way of preventing the repetition of such atrocious behavior, both in respect to war making and in respect to how the state acted toward those that it viewed with disfavor. In other words, there were two aspects to the impulse after World War II. Part of it was to address what came to be known as the problem of aggressive war. And the other part of it was to avoid giving impunity to atrocities that were committed by the state within its own territory. And the primary activating example of this concern was, of course, the Holocaust and the commission of genocide on a massive scale. And so the very radical legal idea of crimes against humanity was initiated after World War II. And that may sound now like a normal category of criminality, but at the time that it was accepted as a basis of legal judgment, it was quite a radical idea, because it in effect said sovereign states and their leadership are accountable not only for what they do to others and to other states, but what they do to their own people. And underneath that contention was the idea that there is a common humanity that is more significant from the perspective of law and justice than national identity or religious identity, any of the fragmentary identities that divide the world. In other words, crimes against humanity is the basis for a species identity that is something that the world still desperately needs. Because my point is, enacting law does not ensure its implementation. And what has been characteristic for this area of international state crime is from its inception, which I'm, for sake of simplification, situating at the end of World War II, there was a double message embedded in that effort at Nuremberg and also in Tokyo. And the double message was, we will hold responsible those who are defeated in wars according to universal norms. And there was the idea at Nuremberg that the norms would be articulated as if they were universal, but the crimes of the victors would not be considered. And if you think about World War II at all, there is no doubt that the victorious powers were also very guilty of grave crimes, grave international crimes, the indiscriminate bombing of German cities, and the use of atomic bombs against Hiroshima and Nagasaki were in public moral consciousness as atrocious as was Auschwitz and Treblinka. In other words, the two words that come out of World War II to stigmatize behavior are Auschwitz and Hiroshima. See, and one is punished and the other is not even mentioned. See, it's that the silence toward the crimes of what I would call hegemonic, for the purpose of these remarks, hegemonic state actors. And hegemonic state actors are those states that are not accountable to law in matters of vital strategic interests. See, and one of the widely held misconceptions is that we live and have lived in the whole modern era in a world order of sovereign states, that it is a state-centric world, a horizontal set of relationships between states that are juridically equal. But always in that world were the managers of hard power, those that didn't feel the sense of any kind of limitation that was beyond what they felt as a matter of discretion. In other words, you had this idea, this double idea of law being based on treating equals equally in its formulation, and geopolitics premised on treating equals unequally. And that was the suppressed premise. If you read the language of the UN Charter, for instance, it is expressed as if the juridical principle is primary. But if you look a little deeper at the structure of the UN, this duality emerges. The UN Security Council gives the veto to the 5 winners in World War II. And what does the veto mean? The veto is just a procedure by which these 5 states can facilitate their own non-compliance with legal obligations. They are literally either below or above the law, depending on your sense of space. But they are this idea that the most dangerous states in the world are the ones that are not subject to the legal order, unless they want to be, is an extremely subversive idea from the perspective of justice. Because if you think about the fundamental idea of justice is the blindfolded goddess who can't see the identity of the defendants and therefore has an objective view. See, and what has happened in relation to international criminal law to a considerable degree is a gigantic mystification by suppressing this geopolitical hidden idea. And so it was not just a matter of victor's justice, which was certainly the case at Nuremberg and Tokyo, that you looked at what the defeated did and you exempted the victor. But it was also a feature that helped to restructure the whole post-1945 world in some of its most important areas. For instance, the control of nuclear weapons was based not on the criminalizing of this weaponry of mass destruction, but rather on distinguishing between those states that had the weapons and acquired the weapons and those states that failed to acquire the weapons, and a very interesting manipulation occurred by which the principal dangers to the international community were situated in relation to the countries that didn't have the weapons rather than the ones that had them and had used them. And this is quite extraordinary, and in recent years it's played out as a pretext for aggressive war. The war against Iraq was a war that was initiated allegedly because of a fear that Iraq would acquire weaponry of mass destruction, initially chemical weapons, biological weapons, but also nuclear weapons. And the whole tension with Iran has been based on the fact that they shouldn't be allowed. It's worth fighting a war to prevent certain states from acquiring the weapons, whereas the states that have the weapons did make a treaty obligation to engage in good faith negotiations to get rid of them. But they've never complied with that, and no one, it's beyond serious scrutiny. That form of one form of non-compliance or alleged non-compliance of the Iranian or North Korean sort can be the occasion for war. But the non-compliance with the disarmament imperative in the Non-Proliferation Treaty is silently forgotten. See, and that's the kind of double standard that I'm trying to address in relation to the basic undertakings of international criminal responsibility, which itself is divided into two parts. The part which is preoccupied with the protection of vulnerable people who are subject to acute abuses of one sort or another, and the punishing of the perpetrators of those abuses. In other words, there's a preventive side and there's a punitive side. And one of the, again, this issue of double standards affects both dimensions. We wonder, and many people are disillusioned by the fact that nothing has been done in response to the Syrian tragedy, that it unfolds before the eyes of the world and nothing happens in terms of stopping the crimes against, the massive crimes against humanity. Whereas when the population of Benghazi in Libya was threatened in 2011, there was a massive NATO intervention to achieve regime change, not only protecting the people of Benghazi, the original pretext, but altering the political character of the Libyan state. And what is, I mean, one difference that one notices is Libya has oil and Syria doesn't. Another difference is that there is a geopolitical motive in relation to getting rid of Gaddafi and an ambivalence toward what happens in Syria. The latest kind of cynical thinking is that the best thing for Israel and the United States is if neither side wins, and the fighting continues indefinitely. And that's been articulated recently. But the double standard here is that there is a great emphasis on the emergence of what's called the R2P norm, responsibility to protect, and that it was given a quasi-legal character by the Security Council a few years ago and applied to justify the Libyan intervention in 2011. But do you hear it mentioned in relation to the people of Gaza? Or do you hear it mentioned in relation to the Tamils in Sri Lanka? Or to the Tibetans? Or quite a number of other people who are in acute need of protection. So that the essence of this norm is the absence of political will where the geopolitical interests are not present in sufficient strength. See, that's what creates these double standards. The political will of the hegemonic actors. Where it exists, the UN can not only be effective, and international law can not only be enforced, it can be excessively effective and excessively enforced. But where it's absent, then it will be, there will be no effort made to induce compliance, or a minimal effort made. So what you have jurisprudentially is a legal order that is based on these universalistic language, but a system of implementation that doesn't treat equals equally. And so it raises a question of justice. Can you have a just system of law when you have this dualism? How do you understand this? And the liberal in the sort of Western sense of liberal associated with mainstream NGOs like Human Rights Watch or Amnesty International, is to celebrate what you can do and ignore what you can't do. So in effect, the liberal perspective doesn't at least acknowledge being disturbed by these double standards, and you rarely hear it articulated. What might be called the anti-imperialist view is disturbed by the double standards and is highly critical of the way in which moral and legal arguments are mobilized to justify intervention or holding some people responsible and not others. Noam Chomsky, during the Kosovo intervention, coined the phrase military humanism to his way of talking about these double standards, saying, why has so much effort been made on behalf of the Kosovars and so little done about the Kurdish people who have suffered in various ways in several Middle Eastern countries. In other words, the ideological perspective on this issue is very interesting and revealing. And as I say, the liberal mainstream looks at the glass half full, and the anti-imperial critics look at the glass half empty. That's, of course, a gigantic oversimplification, but the point, I think, is the Chinese have a proverb: two people sleep in the same bed, but they have different dreams. And I think you have this, these two ideas about what is right and what is wrong. See, and liberals say what is right is incremental progress. And what the anti-imperialists say, what is wrong is the techno-capitalist suppression of the peoples of the world. And that unless you put that perspective into the inquiry, you will, in effect, overlook the real cause of human suffering. So in a way, these two positions are distinct diagnoses of the principal cause of human suffering as a outcome of the way in which politics and economics are organized in the world. And they also have contradictory prescriptions for what to do. The liberal perspective saying, try to do more of what is being done, gradually encroach, and the anti-imperial perspective says it's time to transform the system, essentially. That you can't get to justice from where we are. The structure is sufficiently deformed that it has to be transformed to overcome this problem. I want to give some emphasis to the complexity of this Nuremberg experience, because I think it does cast its shadow forward in interesting ways that are partly promising and partly discouraging. One of the aspects of the Nuremberg experience was the very eloquent statements made by the chief prosecutor, who was a U.S. Supreme Court justice who was given a temporary leave, Robert Jackson, who in some way was sensitive to this problem. And he said in his opening address at Nuremberg, and I quote, "If certain acts of violation of treaties are crimes, they're crimes whether the U.S. does them or whether Germany does them. And we are not prepared to lay down a rule of criminal conduct against others which we would not be willing to have invoked against us." Now, was he lying? He certainly is too intelligent not to have understood that what he was saying was exactly contrary to what they were doing. How do you explain that? And he went on to say in his closing statement, "We must never forget that the record on which we judge these defendants is the record on which history will judge us tomorrow. To pass these defendants a poisoned chalice is to put to our lips as well." See, and in those words were the ideas that yes, Nuremberg was victor's justice in one sense, but it was also a law precedent, a law-making precedent. And what was done to the Germans in 1945 would govern assessments of what the victorious powers did in the future. And this was, in a sense, what I call the Nuremberg promise, that yes, Nuremberg was deficient, but the future would correct these flaws. And he reinforced this with a statement at the very end. "We must make clear to the Germans that the wrong their leaders are on trial for is not that they lost the war, but that they started it. And we must not allow ourselves to be drawn into a trial of the war, for our position is that no grievances or policies will justify resort to aggressive war. It is utterly renounced and condemned as an instrument of policy." See, and what I think is striking from the perspective of the argument I'm trying to make is that in one sense there is this sincere liberal dedication to law as a universal language that addresses equals equally. But then that sincerity is subverted by geopolitics that is more powerful than law and creates these exceptions which are they're not marginal exceptions. They're exceptions that are created to protect the discretion, the freedom of action of the most powerful actors in the system. So it is a way of law submitting to power in these crucial areas of accountability. And if you go forward to the post-Cold War period, interestingly, in the Cold War period, there was a sense of mutual, each side viewed the other as criminal, and so they both had a tacit agreement not to invoke this Nuremberg precedent against each other. But as soon as the Cold War was over, then the hegemonic mood shifted, and it became useful to use this international criminal law instead of doing something to protect the people of former Yugoslavia, of Bosnia, Kosovo, and so. And in response to the failure to do anything substantive to protect the people of Rwanda, where the gigantic genocide occurred. So in order to save moral face in a way, it was useful. It wasn't victor's justice in this sense, but the political will of the hegemonic actors suddenly changed to support the initiation of this kind of imposition of criminal accountability. And what is also important to notice, and part of the liberal argument, is the people that are punished, and this goes back to Nuremberg, are people that have done terrible things and deserve punishment. And in that sense, and they receive a fair trial. So you have that kind of procedural justice combined with the notion that they did reprehensible things. But others did reprehensible things too, those who acted for the powerful states, and they're the ones that have the impunity, and their friends. Israel is a poster child of geopolitical impunity, a geopolitical exemption from accountability to law, not because it's a hegemonic actor itself, but it's under the umbrella, the protective umbrella of a hegemonic actor, which is just as good for these purposes. So what I'm trying to suggest is the Nuremberg promise has been broken without any signs of conscience on the part of the hegemonic actors. They all five of the governments that were sitting in judgment, the four governments that were sitting in judgment at Nuremberg, have committed aggression, have been associated with criminality. And we see the pattern that Slobodan Milosevic and Saddam Hussein are apprehended and punished as indicted and prosecuted as war criminals. Arrest warrants were issued for Gaddafi. In both the case of Milosevic and Gaddafi, the International Tribunal acted while NATO was at war, arguably at a non-defensive war that had not been authorized by the Security Council. So one other thing that was said at Nuremberg was that the greatest crime was the crime against peace, that embraced all the others. So you have this strange paradox of the ad hoc Yugoslav Tribunal and the International Criminal Court issuing legal orders directed at sitting heads of state at the very time that NATO was engaged in an arguably aggressive war or an unlawful war against those states. You see, it shows the complexity here. And then you have the case of the Iraq War, where you have Saddam Hussein and his associates prosecuted as war criminals and executed, many of them, whereas George Bush, Tony Blair, Donald Rumsfeld are given, there's no serious discussion of whether they should be subject to some kind of legal process. And when Rumsfeld, who was the Secretary of Defense and associated with the systematic torture that was used at Abu Ghraib and Guantanamo and Bagram, when he was threatened with being detained in Belgium under the Belgian universal jurisdiction norms, he threatened to have the headquarters of NATO removed from Brussels and relocated in a friendly place. And Belgium revised their laws so that Rumsfeld didn't have to worry about being detained if he came to Brussels. See, and so what is illustrated is that it's no longer so much victor's justice, it's this primacy of geopolitics that creates this dualism in the application of international criminal law. And let me make just a few remarks about what can be done about this dualism. It is very persistent. And one of the things that can be done was already in the ambiance of Nuremberg. And that was created actually by the American president, Franklin Roosevelt, during World War II, where he said the German people had an obligation to collect evidence against the crimes of their government. And this is what I've sometimes articulated as the Nuremberg obligation. In other words, the sense that citizens have a right and a duty to expect their own governments to act within the confines of international law. And that is one of the ways, one of the ways the revitalization of democracy could also produce a juster approach to international criminal responsibility. In other words, the idea that there is an internal discipline. And I've argued and believe that my own country, the United States, would have been much better off if its political leaders had been constrained in their foreign policy by the framework of international law. There would have been no Vietnam War, there would have been no Iraq War or Afghanistan War. The disasters of foreign policy have been associated with deviations from these legal rules which embody the wisdom of statecraft. See, it's part of the, I think, alienation of realists to think that having the discretion to wage war and to use this military machine is an advantage. In the 21st century, it's a disadvantage. And that degree to which we're living in a post-realist world, in this sense, that if you look back to 1945, very few of the conflicts have been resolved in favor of the side with the greatest military power. And for the U.S., the object lesson is Vietnam, where there was total control of the battlefield, air, sea, and land, and yet the war was lost to a low-tech adversary. And look what has happened in Iraq and Iraq and Afghanistan. There is an illusion that you can translate military dominance into effective political outcomes. And until that illusion is understood and integrated into the ways in which political leaders act, these mistakes will be repeated over and over again, because the realist mentality still has this faith in the agency of military power, where the empirical evidence suggests the opposite. So one way that there can be some challenge to this duality is through a greater willingness of citizens of democratic societies to expect their own governments to comply with international law in their foreign policy, and with human rights, of course. And a second way is to empower national courts to use universal jurisdiction and to act as agents of the international order and hold individuals, the perpetrators of crimes, responsible wherever they come from. And there is a kind of low-order success. People like George W. Bush and Rumsfeld and Kissinger change their travel plans because they're uncertain as to where they might be detained in the Pinochet manner and alleged to be responsible for war crimes. And there was this Spanish kind of deviation from geopolitical discipline, where it was trying to prosecute people from Israel and people from the United States and so on. And again, there was a geopolitical pushback, so it's no longer doing that. But the point is that there are potential institutional capacities at the national level that are less manageable by these hegemonic actors. And Bush was not able to go to Canada and Switzerland recently on a quote-unquote book tour because he feared these kind of consequences. And that makes people think a little. It changes the psychic climate a bit to have these things happen. And the Pinochet litigation was very important, I think, in creating, temporarily at least, this awareness. And the final way, I think, of trying to bridge this gap is through civil society initiatives. And one of the more prominent of these initiatives has been the organizing of people's tribunals that inquire into the crimes of the powerful. And this was done in a rather impressive way by the Iraq War Tribunal in Istanbul in 2005, which was the culmination of 20 sessions, earlier sessions, in all major regions of the world, and which had a series of expert testimony that really compiled a very good documentary record of the legal arguments against the Iraq War. And there was a jury of conscience presided over by the Indian writer Arundhati Roy that produced a very eloquent statement on the nature of the moral, legal nature of the crimes that were being committed in Iraq. And this was started by the British philosopher Bertrand Russell in the midst of the Vietnam War in 1966 and 67, where he managed to gather some of the leading intellectuals of the time, including Jean-Paul Sartre, Simone Weil, and others, and they did the same thing. They compiled a very authoritative documentary account of the violations of the laws of war and the aggression against the Vietnamese people that was more comprehensive than anything that governments or the UN were able to do. In other words, there is a role for civil society judicial initiatives, even though, of course, they are condemned by the liberal mainstream as encroaching upon the role of the state and of formal legal and governmental institutions, and they are seen in that way as illegitimate challenges to legal authority. But what I'm trying to suggest is that these civil society mechanisms, including in the context of the Israel-Palestine conflict, the BDS campaign, the boycott, divestment, and sanctions campaign, is trying to take international law seriously and doing what the world of sovereign states is unable to do and unwilling to do, and that the UN is unable and unwilling to do. And so there's a normative vacuum that civil society can not fill, but at least can symbolically challenge or symbolically occupy in ways that I think do create opportunities for pushing law a little bit closer to the realization of justice. And I think that what I'm trying to say overall is that the future of international law in this area of state crime of an international character depends, it seems to me, on bringing the geopolitical actors under the framework of, subject to the discipline of international law, and moving toward a legal order in which equals are indeed treated equally. Let me stop there, and thank you for your attention.
Thank you so much, Richard. I think that was a majestic lecture. I think it was absolutely riveting. And from ISCI's perspective, I found your last contribution really about the People's civil society and the People's Tribunal, especially important because at ISCI we were in the very early stages of setting up a People's Tribunal to look into the persecution of the Rohingya people in Burma. And so we're at the very early stages, so we'll be talking very closely to you while you're here about that, and perhaps anybody who's interested in the audience might like to be in touch with us on that whole question. I think I'm going to open the floor now for questions and contributions. I'm going to do this in an orderly way. I'm going to take 2 questions at a time, and then Richard will come back and so on. So we'll begin here and there, and then I'll come back to the rest. You have to shout rather loudly because we don't have a roving mic, I'm afraid, unless you want to come to the front.
A question I'm going to ask about initially you talked about Hiroshima and Auschwitz. Auschwitz was a crime of commission, they actually went out of their way, they knew what they were doing, and it was a violent crime against individuals. Hiroshima, on the other hand, was actually an act to try and cause a war to finish, because it was a very bloody war. The closer it got to Japan, the chances are the bloodier it was going to get, and it could possibly have saved a lot of lives. And atomic weapons have actually created an element of peace in the world because it hasn't been a major war. There's been a lot of regional wars, but not major wars because people are scared.
I'll take the question at the back.
Thank you. Regarding double standards that you mentioned.
Can you speak just slightly
maybe,
louder?
maybe come closer.
Yes, if you don't mind.
Yes, you mentioned double standards earlier on. Am I correct? Double standards earlier on. Now, in the Gaza Strip, you have Christians forced to convert to Islam. In the West Bank and the Gaza, you have women abused, not by Israelis, but by their fellow Palestinians. Honor killings left, right, and center. You have female genital mutilation rampant in Gaza. You also have when Israelis try to do maintenance, maintenance repairs for the water in the West Bank. Fatah refused. Now, surely one has to be consistent about this. But my question is, now I understand that you are very much involved with the Israeli-Palestinian conflict. How many more Israelis and how many more Palestinians should die in a war for you to get exactly what you want, sitting in the comfort of the headquarters of the United Nations? Thank you.
What, I didn't get the question exactly.
It was a question about, basically talked about genital mutilation in Gaza, Christians being forced to convert to Islam. He's just criticising your position in the UN, sitting comfortably in the UN, as you said. Where is the double standard? So,
Would you like to come back on those two questions?
Sure. You make I made a limited point in my talk, which was that the two, it's sort of an empirical point, that the two atrocities that are viewed internationally as a legacy of the Second World War were Hiroshima and Auschwitz. Maybe I'm empirically wrong about that, but that's my sense is that those two things, and that if I've sometimes argued that if the Germans had beaten the U.S. In developing atomic bombs and had used them against English cities and had gone on to lose the war, that they would have been criminalized as a very serious kind of war crime, and that therefore the impunity associated with the use of these weapons against essentially non-militarized Japanese cities at a time when much of the historical research suggests that Japan was trying to surrender prior to those attacks, and that one of the reasons that the bombs were used was to send a signal to Moscow. It was not owned, and to win the war sufficiently quickly so the Soviet Union didn't get a piece of China and northern Japan. Now, whether that historical record is complicated, and of course, other people hold the view that nuclear weaponry prevented World War III, and that's, again, that's a contention that cannot be validated. My own view has been that this technology is too menacing for humans to attempt to control, that we've been lucky that there's been no use of these weapons since 1945, and that we cannot, and should not rest our own security on the threats to annihilate tens of millions of innocent people and cause contamination of the planet for decades to come. We still, despite the end of the Cold War, nuclear weapons in both Russia and the United States are on alert status, which means they can be fired in less than a minute, in some cases 30 seconds. So we're living in a precarious, what is a precariously and unnecessarily quasi-apocalyptic world, and I think it's a kind of hubris to think that we can indefinitely coexist with this weaponry. As far as I didn't catch the whole of your comment and question, but as I understood it, and of course there are terrible things happening in the Palestinian territory, and it's not actually it's not part of my own role to investigate what Palestinians do to each other and what abuses there are, but there.
Excuse me. I'm sorry. You've asked your question. You've made your comment. Let Professor Falk speak, please.
But I think the essential issues are ones of a situation in which Israel has gradually expanded, has administered a very oppressive occupation.
I'm sorry. You've made your comment. Please. I'm sorry. I'll have to ask you to leave if you're going to keep interjecting.
That Israel has consistently denied Palestinians their rights, particularly the most fundamental right of self-determination, and that there seems to me to be no political will on the Israeli side to reach a viable, sustainable, genuine peace. And that's my basic understanding of the conflict, and it's an understanding that I've received in part by contact with the people living under occupation and to some degree from Israelis themselves.
Thank you. More questions, contributions? So I've got, I think your hand was up earlier, right at the back with the grey shirt, followed by the woman here. You might have to come down if your voice isn't as loud as mine.
So earlier on you talked about the selective use of R2P and how that's an emerging norm, and how I could be misunderstanding how you thought that should be applied to situations like in Tamil Nadu. I just wanted to ask if you thought that emergence of a norm actually undermines the rule of law and means that states can act in a unilateral way rather than working through UN mandate.
Well, I didn't quite get, you say the R2P as an emerging norm?
Yeah, you referred to it earlier in reference to situations like Tamil Nadu, and you said it should be extended to those as well as the ones that has been. Is that correct?
Yeah, but extended through a process in which the use of force was appropriately authorized.
Well, so is that the same as a UN mandate? Is not
A Security Council mandate, yes.
Thank you.
Yes, my understanding of what you have presented.
I'm sorry, we can't hear you. So could you,
Yes.
sorry.
Perhaps a better understanding of what you presented is that we are somehow benefiting from the development
one more question and then man in the black shirt there. And then towards the front. Yes, you.
You mentioned the tribunal in Rwanda and the tribunal for Yugoslavia. You didn't talk much about the ICC, and I was wondering what you thought about the whole Rome Treaty and what with the state around the world has benefit from it.
What do you think about the ICC and whether it's having an impact on State crime?
Thank you. So if you could come back on this.
Oh, sure. Yes, well, thank you for those questions. As I understood the R2P question, it's a potentially constructive norm, provided it's the debate in the Security Council is an honest debate, which I believe the Libyan debate was not, because it claimed to be a protective, humanitarian, limited undertaking, a no-fly zone, but it was, as soon as it was operationalized, it turned out to be a regime change undertaking. And that undermined trust among those states that were dubious about the intervention but abstained in order to allow a limited humanitarian initiative to take place. But that loss of trust, I think, disempowered the UN in relation to the Syrian conflict. In other words, there was a cost that resulted from the misuse of the mandate, the limited mandate that had been given in the Libyan case. And the broader point here is that the central objective of the UN originally, as stated in its own preamble, was to save succeeding generations from the scourge of war. It was a war prevention initiative started because of the sense that war was an intolerable institution and that the only kind of force that should be legally authorized was that of self-defense. And so it's the departure from that, the corruption of that norm through UN practice that has, in effect, nullified that central undertaking after World War II, when the memories were fresh of the devastation associated with large-scale war-making. And it's not that there haven't been large-scale wars since 1945, but they haven't occurred in the West. And if they haven't occurred in the West, they haven't occurred in the hegemonic centers of world power, and therefore they don't matter. See, that's, in that sense, it's still a West-centric world order, which I think has rather profound implications. The very good questions about the media, NGOs, and the failure to apply the law, if I understood, it was not so much the shape of the law, but its selective application. See, I think in all of that the media and the mainstream NGOs in civil society have subscribed to the notion that they must respect this geopolitical exception. That if they challenge that, they will be marginalized and viewed as irrelevant. So you find very little. Sometimes there's a kind of nominal or gentle challenge you find from Human Rights Watch or Amnesty International. But there's great care. As far as I know, none of the mainstream NGOs even raise seriously the question of the indictability of Rumsfeld and the Cheney and Bush for establishing a self-conscious system of torture that was not. It was called enhanced interrogation, but that didn't make it any less torture. The euphemism was a way, and the media more or less was co-opted by this dynamic. And it's an unfortunate reality in at least the US, and I think in other parts of the world, that the media has been co-opted by the national security state, and it has adopted the view that the foreign policy decisions of a country like the United States should be determined by feasibility and strategic interests, not by deference to legal constraints or even moral constraints. And so you have that as the political culture of these hegemonic actors. It's not just the state. It's the state having exerted this kind of ideological influence on the centers of opinion making and norm creation. And again, it's a sign of the inadequacy of the way in which liberal democracies are functioning at the present time, that the media is not independent, it's not sufficiently independent to raise these issues as matters of debate, not necessarily to take the view that I'm advocating, but rather at least to acknowledge that there needs to be some serious attention given to the relevance of international law when recourse to war is being contemplated. And I've collaborated in a couple of books on the New York Times, which shows how systematically they have avoided any discussion of the relevance of international law to controversial foreign policy. And this avoidance is part of the geopolitical conditioning of hegemonic actors to engage in these forms of behavior. Oh, and finally, has the ICC, International Criminal Court, acted in a constructive way? I think it's too early. It's been in existence for a decade, a little over a decade, and it's too early. At the moment, there's a big fight with the African Union that is, I was actually going to talk about it a little bit, in which the African Union is on the verge of withdrawing from the International Criminal Court because of the claim that they only look to defendants in Africa. And the 8 cases that they've pursued have all involved sub-Saharan Africa. Again, as I was trying to say in my main remarks, all of these indictments directed at Africans are directed at people who have done things that are wrong. The argument that should be made is, why don't they direct them at the others that do wrong things. See, it's the incompleteness, the discriminatory incompleteness of the jurisdictional claims that the ICC has been putting forward, and the extraordinary measures that the United States has taken to avoid the potentiality of being accountable. It's entered into something like 100 bilateral agreements with other governments not to turn over any person to The Hague for possible prosecution. And it even there's even a congressional act which authorizes the president to use military force if the International Criminal Court embarks on an investigation of any potential American defendant. See, and that's really reinforcing in a rather blunt way this claim of geopolitical impunity that underlies this dualism. And there's an interesting second level of argument in Africa between the African heads of state that say, we don't want any further acting heads of state to be subject to investigation and prosecution while they're serving. We are willing to allow indictments after they leave the presidency or leave their role. And they specifically demand, as a precondition for remaining in the court, that the proposed prosecutions of al-Bashir of Sudan and Kenyatta of Kenya be deferred for a year, which is possible under Article 16 of the ICC statute, if the Security Council so recommends. And Archbishop Tutu, who says these African leaders are just trying to get a free pass so they can maim and abuse their own people. So you have two levels of argument. One is the sort of anti-imperial claim that this is a court that's just being used against former colonies, especially in Africa, and the moral authority figure of the stature of Tutu, who says we need this judicial assessment, this judicial constraint on the behavior of our leaders, which is intolerable. We can't tolerate this behavior. And he doesn't look beyond the African context and says, this is good for Africa. He doesn't ask the question, is it unjust that Africa is treated differently than North America and Europe and parts of Asia?
I'm going to take, I think Ori's hand was up, Saeed, and was there a hand? Hamza.
Thanks. So two questions. One is the beginning of the talk, it seemed to me that you were talking about international law as something that's been co-opted by great powers, and it's been used as a tool of geopolitical power. At the end of the talk, international law emerges as a kind of solution to certain things, and I found that puzzling. It's not clear to me why you think that, unless the solution is in the margins, international law really is the solution, because if international law becomes powerful enough, according to your initial analysis, it will be co-opted by those in power and will be used for their interests. Therefore, I would be interested in hearing a little bit more about that. Why do you think international law really is this great solution? The second question / comment is the following. I think what I'm going to say may have been animating some of the initial questions that we had. Sometimes when I was listening to your talk, I was wondering, what are you motivated by? And there are two ways of putting it. One is to say, this person feels to me like a radical humanist. He cares about where was Turkey? In your example, where was Africa? So many horrible things happen by these powerful agents, but you don't hear about them in the discourse. It's Bush, it's Israel, and Israel, and Israel, and Bush. And that's, I think, and that may be explaining some of the animosity, right? Or some of these arguments about double standards. So I was just wondering what's motivating you deeply here?
And then Saib?
Great. So thank you so much, Professor Falk. I really find your kind of blend of academic work and your political activism refreshing and extremely fascinating, especially your notion of the citizen pilgrim and how that relates to civil society, and especially in the context of preventing war and aggression. But the thing is, until we actually, and perhaps you'd like to take a moment to talk about the citizen pilgrim, until we actually arrive at that kind of singularity where we start seeing an increase in social movements that elevate consciousness, there are vast problems. And I think one of the most critical problems that you touched upon, and this is the greatest security challenge I think that we're facing in the globe today, is the inequities in the NPT, or the Nuclear Non-Proliferation Treaty. And we continue to see the insincere diplomatic posturing from Israel in Geneva right now, which is leading to a complete breakdown of the talks, and we are moving, I think, closer and closer to that confrontation that we all fear, and that could potentially wipe out the human race as we know it. So basically, where do you basically see this going, and basically Israel's stance in its non-cooperation to move towards a genuine peace?
Thanks, Saib.
Thank you for the lecture. I wonder your thoughts on the current International Criminal Tribunal in Bangladesh, which has both been condemned by the global liberal NGOs, and whether that Legacy of Nuremberg has any reflection and international norms, whatever that is, on the ITC in Bangladesh currently for war crimes.
I mean, what's happening now in Bangladesh?
What's happening with the International Tribunal in Bangladesh?
Oh, I don't know.
Thanks. Well, you can do those three.
Yes. I may not have been clear enough in my attitude toward the role of international law, because for me there's no inconsistency between seeing its problematic sides and seeing its normative potential. And I probably didn't clarify the fact that in the beginning I was focusing more on the problematic sides of it. But international law is a kind of instrument that can be used both by the powerful and the powerless. And it's very important to understand that that it isn't necessarily embedded in a geopolitical order, but it can be manipulated, and the manipulation can be used in the kind of cultural space that exists by media and other shapers of opinion. But fundamentally, international law, as it developed out of Nuremberg, did express a certain set of moral aspirations that I think are benevolent, and if civil society endorses those and tries to implement them, that can be a very positive role that law plays. So for me, there is a compatibility that doesn't feel to me as though I'm being inconsistent, even though I appreciate that you found what I was saying inconsistent. As far as the more provocative question about what motivates me, again, I don't find that there's a dramatic, I don't find the way you do, that there's such a dramatic inconsistency between affirming radical humanist ends and being a critic of imperialist structures. It seems to me that they are compatible. And the same thing with the Western, the legacy, the post-colonial Western efforts to project its influence and power, I see as also an obstacle to the realization of a more humane forms of global governance. So to me, those are different levels of assessing the global situation as it now presents itself to us. And again, maybe I wasn't as careful as I should have been in explaining why they're reconcilable in my own political sensibility. When you complain about the fact that I talk only about Israel and the United States and don't say enough about Russia, China, Africa, and so on, yes, that's true. I plead guilty to that, but it's partly a reflection of my experience. I am an American, and I've had this UN role for the last 6 years in dealing with Israel-Palestine, and that has made me see the world through those prisms. And those prisms seem to me to be important prisms. They're not the whole story. And I completely agree with you that there's lots to be said about horrible things that are happening and being done by Putin's Russia and by, I'm less knowledgeable about China and certainly in Africa. And, but I think I was pretentious enough in what I tried to talk about. I couldn't take on the world in this, the compass of a lecture, and tried to talk about things that I felt strongly about because of my experience and because I feel that I know something about these issues. I'm grateful to you for bringing up the idea of the citizen pilgrim, which is an idea that I've thought about for a long time. It has its origins, as you may know, in the New Testament, in Paul's letter to the Hebrews, in which he talks about that the person of faith is on a journey, is dissatisfied with the world as he or she finds it, but is in search of a heavenly city, that it's a process, and that the notion of citizenship is not something that is spatial as much as it is temporal, that you create a future that is that represents the horizons of desire, and that the citizen pilgrim dedicates his or her life to that future. And it's that kind of normative vector that I was trying to express, and to get away from the notion of world citizen, which seems to me to be overly spatial and to be a kind of utopian view, because there's nothing that sustains such citizenship given the structure of the world. But if you make a temporal conception, that's recognizing the realities of the present, but seeking a different future. And it's in that spirit that I put forward those ideas. I don't really know enough about Bangladesh to give an intelligent answer to your question, so I apologize for that.
I think it's now 8:10. We're going to have a reception downstairs in chapters, and there'll be plenty of opportunity to continue the discussion. I think we've worked, Richard, very hard this evening, and we're extremely grateful that you've taken the time and given us such a demanding and challenging and wonderful lecture. So thank you very much again, Richard.